And there's really two ideas in the Americans with Disabilities Act that underlie all the legal activity that's happening in the accessibility space. One is non-discrimination, which is that participation idea, and one is effective communication. That 30 years ago, the ADA is going to have its 30th anniversary this July. 30 years ago, the drafters recognized that if you're covered by the ADA, you have to effectively communicate. And it's a very flexible idea. And it is why, if you're providing spoken information, you have to have a way to effectively communicate with deaf people. And if you're providing visual information, you have to be able to effectively communicate with blind people. Effective communication of a website is accessibility. So these ideas are baked into the ADA from the start. Can't discriminate, have to effectively communicate. It is true we do not have regulations that specifically say your website must meet WCAG 2.1 AA. But in terms of the legal space, that is not really needed to protect people with disabilities' rights to access digital. I used to have a slide that said the ADA's regs are dead, but the ADA is alive and well, which is still true. I think with so many court decisions, the argument that, we don't have regulations, we don't know what to do, is kind of falling to the wayside. Many of you may be dealing with it in your particular workplaces, but the ADA is alive and well, even though there are no web regulations. Sections 508, 504, and 503, these are U.S. federal government laws. 508 has to do with purchasing. When you purchase technology, it has to be accessible. When the federal government purchases, has to be accessible. 504 is will get money from the federal government. If you're spending it on technology, that has to be accessible. 503 is about hiring people with disabilities. The basic idea of all these laws is that if the federal government is going to spend money, you have to spend money on all citizens. You can't be doing activities where people with disabilities are left out because your technology is not accessible. The Communications Video Accessibility Act, the Air Carriers Access Act, which has specific web regs for airlines, U.S. state laws, many states have laws impacting digital accessibility. Typically, you'll find three types of laws. One is, you could call them state versions of 508, where states say, we are going to purchase accessible when we purchase technology. There's a 504 equivalent where states say, if we give you money to do something in the state, if you're a state university or a state college, then you have to do that accessibly, including accessible tech. And then non-discrimination, which is similar to the ADA. So I invite you to become familiar with the particular laws in your states, and you can use them in your pocket as part of your I don't like military terms. I keep thinking arsenal. Part of the reasons that you use to get the money you need to do your accessibility programs. And then internationally, for those of you who are part of international organizations, the Convention on the Rights of People with Disabilities and international laws are growing. Digital accessibility is being increasingly recognized around the world. I have a couple resources I can put in the chat box for finding what's happening in the legal space internationally. I have something on my website, lflegal.com. The Web Accessibility Initiative has a page, and the Disability Inn also has a page. So very hard to keep up. I will say right now that don't rely solely on what I have on my website. I try to keep it up thanks to the generosity of friends around the world. But if you look at all of those three resources, you're going to get a good picture. Okay, so these laws must be enforced in order to be implemented, which is, the apples have to get baked inside the pie. So how do laws get enforced? How do the apples get baked? Activism. Even though I'm a lawyer and I'm going to talk about the cases, I'm going to talk about what the courts are doing, I think it's really important to remember that every single day, people with disabilities are using the laws to advance accessibility by calling up the companies, filing a complaint, asking for what they need. Most people, including most people with disabilities, do not want to go to a lawyer, do not want to file a lawsuit, don't even want to do kinder, gentler, structured negotiations. So this is a picture of a protest in San Francisco in the 1970s. If you're not familiar with the 504 demonstrations, I would just recommend to you Drunk History has a great session. They do history from like a drunk perspective on the 504 demonstration, which was the biggest, longest sit-in of a federal building in the history of the United States, all to make sure that Section 504 had teeth and could be implemented. Collaboration and structured negotiation, as John mentioned at the top, I've written a book about this, and this is how me and my clients and my colleagues have worked on digital accessibility issues since the 90s. I believe in collaboration. I haven't had to file a digital accessibility lawsuit except for one time in all those 25 years. And I invite you to pay attention in March when it will be the 20th anniversary of the very first web accessibility agreement signed in the United States that my clients and I and colleagues negotiated with America, who has long been an accessibility champion, not with a lawsuit, but with bringing businesses and individuals with disabilities together to really understand what accessibility is all about. So I won't go into too much more. Structured negotiation has been used with Major League Baseball, American Cancer Society, a lot of government agencies, all premised on the idea that people can collaborate and learn from each other to advance accessibility instead of the sort of Wild West situation we have now in the legal space. Government activity. I illustrated this with there's an index finger with a tiny little chip on it to illustrate, there's this theory of the shrinking size of technology. Well, government activity has certainly shrunk over the past 4 years of the current administration, but there has been a long history of the United States Department of Justice being very involved in digital accessibility. Everything that was done under the Obama administration is still up there on the website for all of you to use. There's state governments, there's other government agencies helping to advance digital accessibility. We're not getting much out of the federal government right now, but my hat is off to those staying in the federal government during these very, very difficult times. But government activity is a way that the law is being used to enforce digital accessibility. Civil rights lawsuits. I know everyone here knows about civil rights lawsuits, and I want to talk about that for a bit. I illustrated this slide with a statute that's outside a New York City courthouse, and it's very old. It's a statute of guy, a very big book on his lap, and the inscription is, "Every law not based on wisdom is a menace to the state." And I chose this picture because the ADA is based on the wisdom that disabled people have a right to participate in society. And lawsuits have been a way to enforce that wisdom. We're going to talk in a bit about some lawsuits that are about web access, but not about that wisdom. But it's really, I just can't emphasize this enough, that any concern any of us have, myself included, with some of the types of lawsuits being filed should not take away from the fact that civil rights lawsuits are such an important part of enforcement and have been for a long time. So who is using civil rights laws to advance digital accessibility? I have a list here of the type of people with green exclamation point, who are using the laws. And, sometimes if you just name the case, Smith versus whatever, you forget that it's people involved. So this is just a list of some of the types of people who are filing lawsuits about being able to participate in the digital world. Learners, employees and applicants, retirees, voters, the public, patients, people who eat, people who shop, people who camp, and others. So I have the plus mark. So again, digital accessibility is including people with disabilities in the technology world. And the ADA is about the civil rights of people to participate. And that is what many of these lawsuits are about. So I want to talk about some of the lawsuits. Obviously, there were close to 3,000 lawsuits filed last year in the digital accessibility space, most about websites, a growing number about mobile applications. We obviously can't talk about 3,000 websites, but I just want to give you a feel of some of the kinds of cases that are civil rights cases. So learners, probably the most important thing to come out on the educational space is the settlement between Harvard and the National Association of the Deaf that was announced, I believe it was in October. I have a bit.ly short link on this slide, and this link, which I will read out in a second, is to the actual settlement. So I invite all of you, especially in education, but in any sector, to take a look at the actual settlement. There's a lot of details because this is now, it is a settlement of one case, but the National Association of the Deaf, the Disability Rights Education Defense Fund, the Civil Rights Education. Oh, good. John just put it in the chat. The Civil Rights Education and the Disability Rights Education Defense Fund, the Civil Rights Education and Enforcement Group in Denver, and Disability Rights Boston in Massachusetts were all involved in negotiating the settlement. So in my mind, those organizations who are very reputable and ethical organizations, by negotiating this, the settlement kind of becomes the gold standard for captioning, which was its focus. So it's bit.ly/NAD and Harvard, with NAD and the H in Harvard capitalized. You can look at the settlement. I think some of the just sort of highlight points, there are some types of video content that has to be captioned within certain timeframes. There's other types that have to be captioned upon request. The request timeframe is 5 days. 5 days. So you can't do captioning requests in 5 days unless you have a system in place to respond. You have a good internal procedure. You have a good method of doing it, or a responsible vendor. So I think that's one of the things to look at. Another thing, when you're looking at the settlement, look at all the types of content. There's something about Harvard's YouTube channel. There's something about videos made off-site and then uploaded by professors. So very important new settlement agreement. There's also a companion case that the National Association of the Deaf filed against MIT, and that is still pending. Whatever's happening with that is confidential at this point, so I don't really have anything to share. One thing you'll notice when you read the Harvard NAD settlement agreement is that Harvard agreed in the settlement not to challenge attorney's fees. I had the number. $1,575,000. They agreed not to oppose that. Harvard 3 times tried to throw this case out of court. And Harvard also was working on accessibility the whole time. So it's just kind of a thing to note that when you fight this, it's going to cost money, because one aspect of the civil rights laws is that usually in the United States, people have to pay their own lawyers. But in discrimination cases like race, gender, disability, if the plaintiff wins a case, then the person who loses a case has to pay their attorney's fees. This has been the case long before the ADA, to recognize that protected groups like I said, women, racial minorities, people with disabilities, have a right to have lawyers to enforce these civil rights. So this is a cautionary tale of what can happen when you fight these cases.